functionality of the system with regard to the sale of pharmaceutical products which were required by law to be sold in the presence of a pharmacist. The court thus needed to determine where the contract came into existence.
Medical Association sued the defendant for violating Section 18 of the Pharmacy and Poison Act 1933 in UK. The articles manipulate that it is illegal to sell any drugs on the list without inspection by a registered pharmacy. According to this case, the defendant changed the store into a self-service store. After the customer enters the store, he can pick up a basket, select the medicine from the shelf and put it in the basket and take it to the counter for the payment. Therefore, a registered pharmacy in front of the payment counter who can prevent customers to obtain any medicine if necessary.
Issue or the question was whether the contract of sale was concluded when the customer selected the product from the shelves, in which case the defendant was in breach of the act due to the lack of supervision at this point, or when the items were paid for, in which case there was no breach due to the presence of the pharmacist at the till.
This case upholds the legal concept of invitation to treat. The concept continues to apply in many situations. For example, for things outside the goods seller control, and it will be illegal to carry out the transaction without supervision, such as potentially dangerous goods. As we can see that products on shelves only constitute invitation to treat. Both the offer to purchase and acceptance of the offer occur at the till, where a pharmacist may supervise the transaction. The cashier, under supervision from the pharmacist, may refuse the transaction when the customer took the goods off the shelf and handed them to the pharmacist at the cash register. This was an offer by the customer to buy. At this point, the pharmacy could query the choice and not proceed with the sale. The sale only took place when the pharmacist accepted the customer offer by accepting the customer money. Therefore, both cash was not in the breach of law.
Example of boot cash chemist in this new era is Watson. Under Section 18, Stock 1, a pharmacist needed to supervise at the point where the sale is effected when the medicine was one listed on the 1933 Act Schedule of Poison. The society argued that display of goods were an offer, and when a shopper selected and put the medicine into their shopping basket, that was an acceptance.
The act of display on the shelf is only an invitation to trade, not an offer. Therefore, the fact that a customer pick up a medicine doesn't mean a commitment to a sales offer, and the customer purpose is the purchase offer is permitted by the party asking price.
The judgment was a landmark one in terms of determining the difference between an invitation to offer and an offer. This case demonstrates the difference between an offer and an invitation to trade. An invitation to trade is not an offer that can be accepted. It is an offer to consider offers or an initial approach to others, inviting them to make an offer which may or may not be accepted. The judgment holds ground in present-day scenario as well and clearly presents the contractual stages of purchase and a self-service store.